Can I start by acknowledging the fact that it's my first appearance for your leadership in the new position.
Indeed.
Thank you. And just a word of congratulations.
Thank you.
I want to make 3 submissions in support of the relief sought by the EFF. We don't have the same problem with the ADVs, but we have challenged both the decisions of the Standing Committee and the resolution of the National Assembly. So the difficulty that Parliament puts up, not that it is valid, but so the submissions we will make in support of the interim relief to suspend the operation of the committee decisions as well as the adoption by the National Assembly. The first one is a narrow one relating to the rate increase. We will submit that in addition to what Mr. Bishop has said, the rate increase is substantively unconstitutional. I will deal with the implications of Section 9 of the Constitution. The second part of that argument is I will submit that the process through which the VAT increase was adopted is itself irrational and not constitutional. In fact, it has elements of deception because what they did, the minister and those who sponsored the increase created the impression that it was subject to change. When you now read their affidavit, they say that they've always known that it was never subject to change from the 12th of March. So if you are a public representative and you go to Parliament and you tell the don't worry, vote with me, this may change, you are deceiving them. And that is the improper use of public power. The third argument would be then to challenge the fiscal framework under Section 8.4 of the Money Bills Act. We have prepared a chronology which I will refer to when I deal with the third part of the argument. Maybe I should end this up.
I'm just asking if my constitution applies. My pencil case. It's not there.
So let me then deal with the third argument why we submit that rate increase in the unconstitutional. The first is just to set the constitutional scheme for budgeting decisions, which we have attempted to set out in our head of argument. From page 1311, paragraph 25 of the head of argument. The first point we have is that the budgeting power is constrained by the Constitution. All budgeting decisions are constrained by the Constitution. And the constitutional constraint is not only the principle of legality, another constraint is the Bill of Rights itself. And we say the fact that the Bill of Rights has a constraining effect on budgeting decisions has 2 implications for us. The first is that when budgeting, there is a positive duty to achieve equality. And that is spelled out at paragraph 25.1 from the Manchester decision. The second implication is that there is a negative duty not to take regressive measures. Sometimes they're called retrogressive. The report calls them regressive. But those obligations apply when you are taking decisions such as budgeting. we say that there are a number of judgments that have had budgetary consequences that have been taken by our courts. And the courts have never shied away from making a ruling where the Bill of Rights is implicated simply because the word budget is mentioned. We referred to those cases from paragraph 26.1, Rail Commuters Action Group versus Transnet, 26.2, the Blue Moonlight decision. In fact, Blue Moonlight was even more inclusive because the state argued in that case that it had not budgeted for something. It was not even budgeting, but doing it inappropriately. And the Constitutional Court said it is not good enough for the state to state that it has not budgeted for something, if it should have indeed planned and budgeted for it in the fulfillment of its obligations. And so we say here in this case where the committee itself, because I will go through the report of the committee and I'll isolate the item, took the view that the VAT increase was a regressive measure. It also took the view that the VAT increase would exacerbate inequality and adversely impact the poor. And both Parliament and the Minister simply do not engage with those arguments. In fact, Parliament says it's an irrelevant fact. But it's pleaded expressly in the founding affidavit of the EFF as a material.
Can I just ask Mr. Ngcukaitobi, doesn't this take us to the policy-making arena and the decisions that have to be made by other arms of the state and not the court?
Well, we submit that even if it does, even if you are crafting policy, which is the core function of the executive, it must still comply with the Bill of Rights. And you still have the obligations that are both negative and positive. And so it's not outside of judicial scrutiny. So we say that what the minister also simply does not engage with the arguments. What he does is to traverse trite territory about polycentricity, arguments that have been long rejected because it has long been accepted that the mere fact that a decision is polycentric does not mean that it is immune from judicial review. So we say that our courts have not viewed budgeting as a constitutional holy cow. And we set out all of the judgments that have budgetary implications that have been made from footnotes 20, 21, 22, and 23. So then, what are the facts in this case? What do the facts show? Firstly, the EFF alleged at page 07/4 from paragraph 110 of the founding affidavit expressly that the rights that will be impacted are the rights to substantive equality, particularly of the poor, that stand to be hit the hardest by the unlawful VAT hike. Section 9. Section 10, paragraph 1102. Section 25, paragraph 1103. Section 27, paragraph 1110 and 1105. Section 29. But for my purposes, it's enough to stick to one right, which is the equality right. What the committee itself found, you will see at page 02/128, at paragraph 6.23.3. And this is the conclusion of the committee. I think Mr. Bishop said something about this being a recording of the submissions. No, it's actually a conclusion of the committee. That's how they assessed the evidence in front of them. They said, and you see this at 628, where they say the committee notes that the proposal to increase VAT by 0.5 percentage points in 2025 and 2026 which will take the VAT rate to 16%. The committee further notes the following, so that's their finding. 6.283, that increasing VAT would have a proportionate effect, adverse effect on the lower and middle income households, exacerbate inequality and the cost of living due to its regressive nature. And later on at 6.286, they say the following, that most stakeholders, however, have strongly opposed the VAT increase, particularly in the context of the ongoing cost of living crisis. That's actually a gross understatement. What had happened is that there were 48 submissions. Only 2 supported the VAT increase. It was PEP and PricewaterhouseCoopers. Every other submission rejected it. So you have a scenario in which the public participation process and the VAT increase is opposed by more than 98%. In fact, it then becomes a farce. The whole participation process becomes totally farcical. So when they say most stakeholders, what should have been here is that about 98% said no. 6.287, they say the following. The committee therefore acknowledges that while the VAT increase contributes significantly to the revenue framework, it raises serious equity concerns and must be carefully monitored for its impact on low-income households. There is a need for ongoing assessment of mitigation measures and transparency regarding the revenue base and how it supports inclusive expenditure priorities. I will say that there was no such inclusion. They noted the problem that there are equity concerns, that there should be mitigation measures, but there were no such mitigation measures.
Doesn't this issue not go to the question of ambiguity or the fact that the conclusion reached or the conclusion reflected on the report is not supported by the narration of the committee and what the committee actually debates and finds in its report?
Look, my lady, if I may say, this is an excellent point. It addresses I had seen it as an equality point, but it's also a rationality point. And then the solution, if one recalls, that was proposed by the minister was to zero rate certain items. But that is expressly rejected by the committee at 6.30, where the committee says, the committee notes the National Treasury's position on zero rating is a blunt instrument, as poor households still pay VAT on non-zero rated products and services. The committee recommends that the National Treasury should consider the recommendations made by the stakeholders on the list of zero-rated items, which include an establishment of an independent expert panel to advise it. So they did not find that the zero rating is sufficient protection for the inequality problems that the increase would exacerbate. And then at 6.31, as the committee notes the decision to not adjust PIT brackets for inflation, generating 19.5 billion in additional revenue. And then look at what happened next. The committee is concerned about the impact on lower and middle income households and recommends that National Treasury assess the equity implications of the fiscal VAT and explore alternative progressive tax measures. And at 6.33 on the same page, the committee recommends that National Treasury and SARS should reconsider these proposals and engage further with the stakeholders to assess the viability of selected alternatives, especially where proposals are supported by credible empirical evidence. So I've taken 6 parts of the report where the committee itself acknowledges expressly that the 0.5% will exacerbate inequality. And this is in a country which already on the Gini coefficient is the most unequal in the world. Now, none of these were actually considered, and these concerns, when the decision was made. The mitigation measures that were mentioned were simply not brought into operation. So it's therefore clear on the facts that the 0.5% percentage increase is a regressive measure. It exacerbates inequality. It is therefore in breach of Section 9 of the Constitution. You would therefore expect to find a substantive justification in the answering papers. The problem is that the answering affidavit of Parliament avoids the topic altogether. In fact, it says this is not the issue. It's not clear how they could have come to that conclusion in the light of the EFF intervention. It spoilerates the problem. And then you think, well, maybe the minister will give a substantive justification based on the equality consent. But you also find that the minister does not, in fact, justify the 0.5% other than by saying we need additional revenue to cover a number of other government spending requirements.
Does it not say to ameliorate that we're going to increase the number of goods that are zero rated?
Yes, but that's already been rejected by the committee itself, because it said the zero rating is a blunt instrument because the poor still have to pay for the other goods that are not zero rated. In any event, there is no zero rating right now because it is yet to happen through this independent panel that is yet to be zero rated. So at the time the decision is made, there is no evidence of what is the impact of zero rating on the poor.
So by the 1st of May, there will be no zero rating to speak of.
There will be no change in zero rating. But the poor must pay the percentage increase.
Well, in fact, there's no panel yet.
There's no panel at all. So that zero rating, as Parliament said, is a blunt instrument. It doesn't take us anywhere. So we have a scenario in which there is a clear violation of constitutional rights. The two organs of state that are responsible for budgeting have forgotten their constitutional obligations to the poor. And we don't have to succeed on a final basis. This is a case that depends on the prima facie right. So we say that is sufficient. And here it is not as if there are no alternatives. And again, we don't have to take the EFF alternative. The EFF says you must tax the rich. But you can ignore that and say that's political rhetoric. But what you cannot ignore is the Commissioner for SARS, who himself says there are alternatives. And those you will find at 02/121 under paragraph 5.2. And the last paragraph there, where SARS is making the presentation, and they say the presentation estimated South Africa's tax gap to be between.
Sorry, where are you reading from?
I am at 02/121.
Yes, I'm there, but
Yes, at the last paragraph under paragraph 5.2.
5.2.
Yeah.
Okay, let me just get there.
Yes.
Yes, give me proceed.
So this is what SARS says as clear alternatives. The presentation estimated South Africa's tax gap to be between 700 and 800 billion annually, with only 58% of the theoretical tax liability being collected. So that's 42% uncollected tax on time. SARS identified key under-resourced areas, including illicit trade, syndicated tax crimes, aggressive tax planning by large businesses, international tax compliance, high net worth individuals, cost of entry, and debt recovery. So that's where they say the money will come from. SARS outlines immediate and medium-term plans to enhance compliance and revenue recovery. These include expanding the debt default recovery program, which is in a pilot phase, resolved over 600,000 cases and collected 25.2 billion in cash over 15 months at a cost of 300 million. SARS plans to increase full-time equivalents from 858 to 2,500, with the goal of collecting 20 to 50 billion annually. Additional strategic investments of 2 billion per year are required to support this effort. And then that goes on to the last paragraph in that page. So the point is that Parliament itself and the Minister himself were told by the Commissioner of SARS that there are alternatives to the rent increase. They were not told by my client or the DA or anyone. They were told by their own commissioner.
I'm just going back to the policy choice question and the courts. How far can the court interfere in that arena, where SARS says and the minister says, well, these are the policy choices that we've made. We've looked at alternatives, and we find that it will leave the poor worse off than this other one. Can the court say that?
Yes, if the Bill of Rights is implicated. But the problem is that the Bill of Rights is actually the trump. So you have to make those. The law is not that the government can simply assert that you've made this policy choice. The law requires the government to account by reference to the standard in the Constitution or why they have made policy choices and why they have rejected certain alternatives which were made available to them. So there is no constitutional blank check simply because you use the phrase budgeting. And so that's just a narrow case. In circumstances where, one, it's clear that there will be an exacerbation of inequality, and two, it's clear that Parliament itself says there will be inequality, and it's clear that there are available alternatives. It's arbitrary then in those circumstances to suck your thumb and say, I'm sorry, I want to increase. So what we are asking the court to do is to be more exacting in the evaluation of the conduct by the minister. So we submit, therefore, that there is a strong substantive argument in favor of suspending the decision pending a review in Part B. And we say when we actually evaluate the answering affidavit, there are no direct answers. But when you look at the answering affidavit of the minister, it starts at paragraph 68 in the EFF answer, just never answers anything that comes before paragraph 68. Then I must move on to the second problem that we have, specifically just on VAT. The second problem is that what they seem to have done, the minister and those who promoted this vote in Parliament, is that they have simply said, look, since the Action SA failed for it. But it doesn't matter, Action SA were acting as members of Parliament, not as a separate political party. Also say, look, don't worry about this. We can put in a condition that we will change this in due course. So vote for it. Now, there is a fundamental problem with adopting that approach. It may be politically convenient, but it's deceptive. And public power should not be used deceptively. Public power, the first and the primary duty is that you must be honest.
Now, the minister's decision has not been directly attacked by the EFF.
No, we say that we don't have to because our challenge is, because you remember that the deception did not come in the introduction on the 12th of March. It came on the 1st of April. So we say you've got to look at his conduct in totality. His conduct in totality reveals deception.
Yes, no, I understand that. But what I'm saying, the relief sought, there's no, if I recall, there's no order sought against the minister's decision to say you impugn this decision, this conduct, and therefore the decision must be set aside or must be reviewed or we must do something about it. So there is no direct challenge against the minister. That's what the challenge is against the reports of Parliament.
Your leadership is correct. What we submit there is this, that the minister's decision under Section 7.4 is part and parcel of the budget. Unlike the DA, we don't accept that if the fiscal framework is set aside, there is a self-standing decision of the minister that survives the setting aside of the fiscal framework. Our reading of Section 7.4 is that the two are inextricably connected, especially when you look at the text of the section, which says if an increase is contemplated as part and parcel of the budget under Section 27 of the PFMA, then the following must take place. We see that as meaning that because the increase is part and parcel of that budgeting in the fiscal framework, once the budgeting in the fiscal framework falls, so does the minister's decision.
So once the resolutions from Parliament are set aside,
Yes.
then you're saying Section 7.4 cannot come into operation, or rather the announcement cannot become effective on the 1st of May.
Not independently, because this is what the minister again has said. It really becomes a problem when politicians act like this. Throughout, the minister did not on the 1st of February say that I'm trying to increase VAT. He said on the 12th of March, I'm trying to introduce a budget that includes a VAT increase. That's what he said. Throughout, he always accepted that the two go hand in hand. The first time there was a theory of separation is when the answering of it was fine. So even his own conduct showed that he understood the two to go together. So that's why it's not appropriate right now to try and separate the two decisions, I wanted to say.
So the VAT increase is tethered to the annual budget.
Precisely.
And tethered to the annual budget is a resolution approving the fiscal framework.
Precisely, yes. And throughout the debate, the main issue that the parliamentarians debated was the VAT increase. When they were trying to adopt the budget and trying to pass the fiscal framework, they debated the budget.
But where's the deception?
No, that is not the deception.
Oh.
The deception is the idea that this is subject to change. When they knew that they had no intention of changing, that was deceptive.
Ngcukaitobi, is that not politics?
Yes, but there is no problem with the politics per se, but what we are concerned with here is the conduct of the members of parliament in parliament and the message they are sending to us as the voters.
Mr. Ngcukaitobi, isn't it perhaps just a misunderstanding of the whole legal framework, of the fiscal framework? How it impacts and how it fits into one another. Wasn't there perhaps a misunderstanding rather than a deception?
There could be there could be a misunderstanding, I accept that. But where the minister today, one looks at his answer and says that I never thought this was going to change from the day I announced it on the 12th of May.
So he knew beforehand.
He knew beforehand. So it can only be deception when in Parliament the impression was created that these recommendations can be put and these recommendations can be altered. In fact, my Lord, I'm glad you raised that question because it's not me saying this. It's actually Mr. Trolip. If you go to page 07, so 18.
Just give me a second. Yes, I'm there.
Yeah. So 0.18, paragraph 47 says Trolip, who is an MP and actually can say his nationality is on record, making this exact point in the media briefing he hosted on 2 April 2025, following the National Assembly and NCOP's adoption of the impeachment report. In that briefing, he made the following statement. 47.1, as per its negotiations with the ANC, Action SA's support for the fiscal framework is conditional on the finance minister scrapping the VAT interest recorded in the annual budget and fiscal framework. 2, having expressed his irritation with his perception that the ANC is reneging from its appointment and misrepresenting the facts leading to the adoption of the impeachment report, Trolip asserted that the ANC must implement Action SA's recommendations, which were the preconditions as stated. 3, pulling out his phone and reading his negotiation exchanges with the finance minister, he stated that the latter said to him, I imagine you will be able to come up with proposals to replace the revenue proposals, to which Action SA made its conditional support proposals. It was at this point that the poison tree blossomed and gave rise to the impeachment report fruit. It is that sequence of events that gave rise to this amendment proposal, as agreed with the finance minister and the ANC. Then it goes further. 4, Trolip went on record that following that precondition and concession, Action SA then approached and convinced Bosa and Rise Mzansi to vote in favor of the impeachment report adoption. He repeated the condition in another interview to which I will refer to in a moment. So, it is him who said the minister has misrepresented the truth. So I say that the minister is guilty of deception. So once you have a budgeting process that is so colored by deception, it is fundamentally in breach of the duties of the members of parliament, especially our executive, national executive committee. So you cannot endorse a budgeting process where the deception is so clear. And in fact, you know, my lady, I've been reading from paragraph 47. If you actually go to the minister's answer affidavit, so fine. The answering affidavit starts at 035. There's something that will shock you because the answer to the EFF is at 0351.
Zero.
0351.
Yes, I'm
That's
there.
where the answer to the EFF starts, the seriatim. And you see where it starts at paragraph 85. And at paragraph 47, which is where the accusations of misrepresentation are made, it's just not answered.
Sorry, you on zeros?
0351, and I'm comparing that with 0719.
Okay, yes.
So if you go to 0351, when they start the seriatim response to the EFF at paragraph 101, they start with that paragraph 85. So compare that with paragraph 47, where the accusation is made by Trolip that the minister is guilty of misrepresentation. That is a very, very serious accusation. You would have expected that it would be met frontally. It's just not an answer.
So what must we make of that now?
Well, it still comes back to whether or not a report that is undermined by deception and misrepresentation can pass the rationality standard. Because remember, the EFF challenges this report on substantive unconstitutionality and irrationality. One of the grounds for irrationality has been highlighted by the leadership presiding, which is there's a mismatch between the content and the outcome. But another one is that this is a report that is a product of deception. It's not honest what happened here.
So at the time the minister engaged action essay, he knew that the VAT rate which he announced on the 12th of March cannot be changed.
That's what he says now in the answer affidavit. He says from the onset, I made my decision on the 12th, and that was it. So then that calls into question then what on earth was it doing with Trolip library? So you will see this right at the beginning of the minister's answer. I'll find it now. Yes. So it starts at 03.5, paragraph 15, where he says, I exercise this statutory power, talking about section 7.4, on 12 March 2025. Then next please. There is a specific paragraph that says that it's where they deal with the separation, where they say it's clear that these two are separable, and once announced, it cannot be changed. I will find it. If I don't find it before I finish my argument, I'll tell the court at a later stage. Yes. It's 0324, where he's talking about the implementation of the VAT decision. So paragraph 48, and then paragraph 50, where he said, that said, the decision as to whether to give it permanent effect to the VAT rate adjustment now lies with Parliament. In due course, Parliament will consider.
Sorry, let me just get there.
0324. So the first one is the very top of 0324, paragraph 47.
Let me just get there.
In fact, 0323, paragraph 46, that's where it starts. Yes, now found.
Yes.
Since its announcement, the decision has been widely communicated across the country, and businesses and consumers alike have relied on it in planning for the financial year ahead. Paragraph 47. The VAT rate is therefore set to increase to 15.5% on 1 May 2025. and paragraph 50 at the same page, that said the decision as to whether to give permanent effect to the VAT rate adjustment now lies with Parliament. In due course, Parliament will consider and debate proposed legislation, and to the extent it sees fit, pass or amend it in accordance with the procedures set out in the Manifest Act. So it comes back to this point. I'm asking rhetorically, what was he doing misrepresenting to Trolip, which he has not answered in our founding of today, when he knew on the 12th of March that on the 1st of May, this increase comes into operation? What were they trying to achieve when they said there is 30 days from which you can come back and redebate the issue? So I'm saying that deception is anti-constitutional.
But is it not so, Mr. Ngcukaitobi, that it ultimately was in the hands of Parliament?
Well, it is still, technically speaking, now in the hands of Parliament. Right? What I am suggesting is that even in Parliament, if a vote is procured through deception, it is still unlawful. You could say that it is a matter of politics, and you've already said so, just established. But I'm not sure what
That's the question. I'm not a politician.
Yes, I'm not sure, Justice Savage, what that means, because there are several candidates about what that statement might mean. The one is that South Africans must accept that politicians will lie in the course of doing business. I don't have a problem with that. I have a problem with it when they're discharging constitutional functions. But if they're sitting in Lutuli House and lying to each other, there's no problem. But what we are dealing with here is a matter of immense national importance.
Do we not know that what was occurring was the ANC was needing support for its budget? So it was looking for supporters. It was looking for support from other political parties.
Yes.
So that was part of the process, was trying to secure it.
It is absolutely clear. That's what they were trying to do. The problem
But there's nothing wrong with that, but they shouldn't deceive the public.
precisely because the contamination with deception is in the report itself. Because it's the report that says we come back in 30 days. So once the report is contaminated by that deception, then it is unlawful. It cannot be given legitimacy by the court.
I just want to understand, there's two players here. We're talking about deception by Parliament or the committee, and the deception by the minister.
Yes.
So the one you're dealing with is the deception by the committee.
Yes.
And is that, did the committee actually understand? Didn't they think that, well, ministers must still come back to us? Is it a matter of deception, or is it a matter of maybe misunderstanding the legal framework or the 7-4 powers that the minister has?
Well, there are two candidates. Maybe the two of them are together. Certainly on the minister's side, who now claims that I've made my decision, it comes into effect on the 1st of May, a case of deception can be established. But when it comes to what were the parliamentarians doing when they included in the report that this matter will come back, were they trying to deceive the public, or were they genuinely confused? If they were genuinely confused, it's still irrational.
No, I get your point there.
Now, so we will submit therefore that on both of those two grounds, there is a substantive unconstitutionality problem and a deception stroke grave confusion. And both of those contaminate the VAT rate increase so significantly that it cannot be given a stamp of approval by this court. That takes me then to the last of the three. That takes me to the last of the three, which is what actually happened in the committee. So the starting point here is Section 8(4) of the Management Amendment Procedure Act. So the section states the following. So section 8(1) starts by saying that the National Assembly and the National Council of Provinces must refer fiscal framework and revenue proposals to their respective Committee on Finance. So it's a clear obligation that it must go to the Committee on Finance. Section 8.2, the committees must conduct joint public hearings on the fiscal framework and revenue proposals. Section 8.3, the committees must within 16 days after the tabling of the national budget submit a report to the National Assembly and the National Council of Provinces as the case requires on the fiscal framework and revenue proposals. And then section 8.4, the report must include a clear statement accepting or amending the fiscal framework and revenue proposals. So there seems to be three distinct duties. The first is the National Assembly duty to refer the fiscal framework and the budget to their committee. The second duty is once it is in the committee, there is a duty to conduct joint public hearings, both on the fiscal framework and the revenue proposals. And it must be tabled to the NCOP, but when it is tabled, that report must include a clear statement accepting or amending the fiscal framework and revenue proposals. The EFF's case on this score is twofold. The one is to criticize the process of deliberation that took place at the committee itself. That process of deliberation was farcical. Now, if your leadership will not go through the document I handed up, you will see in comparison, I think it's the 8th page. You will see a comparison drawn from the tables of what we say happened at the committee. There are 10 items that have been isolated there. And what the Speaker says and what the Minister says. And so we've classified this in the heads of argument as absence of deliberation, and we've cited various constitutional judgments that show that the heart of Parliament is a deliberative assembly, so there has to be a meaningful engagement and a meaningful participation in the substance of what is presented before them. So the first one is that the criticism is that there was a request to the Speaker by the EFF.
Paragraph? Which paragraph?
Well, it's the first paragraph, paragraph 12. These are not numbered, but they are in table format.
Okay.
So,
This is the letter that was sent to try and stop the
to
vote.
try and stop it, yes. Which is admitted, but the Minister says nothing about those. But the point here that is made is simply this: these are not the irregularities were brought to the attention of Parliament. It is not as if Parliament was unaware of the irregularities that the committee were brought to its attention. So it approached this task with its eyes open about the problems. So it therefore accepts it. I know that the Speaker of Parliament responded to the DA and said that her advice is that there were no irregularities. That's all fine. But the point here is that if there were irregularities, these were brought to the attention of the Speaker prior to the vote. And so when they voted, their vote was to endorse those irregularities, which is not allowed by the Constitution. Then the second allegation that is made is this, and I think it was debated with Mr. Bishop was writing, which is, however, this conclusion and the insertion in the impugned report, that's the insertion of the word accept, was done post the sitting of the Finance Committee and was not in fact deliberated upon and concluded by the Finance Committee, despite Sinawo Tamu, who's from the EFF, having proposed at the beginning of and halfway through the sitting. The Finance Committee starts off by taking a position on whether it accepts or wishes to amend the fiscal framework to in turn inform the report it was sent, not the other way around. Now look at what the answering affidavit says of Parliament in the next column. It is correct that the insertion was made post the sitting of the committee. I refer to what I've stated and maintain that it reflects an accurate account and statement of what occurred at the meeting. The remaining allegations are denied. Now, that allegation is very important because she never identifies where the item that is being voted on, accept or amend, is ever presented to the committee during the deliberation to vote. Never identifies.
It's common cause, it was not there.
It was not there. But what is concerning is the vote denial by the Speaker, who is herself a repository of public power, where she admits that the insertion came afterwards. And then there is a third, and again, this is not a technical fact, it's a fundamental element of Section 8.4 based on the rule of law. They have been given the power, and the Parliament has decided this is how the power has to be exercised. But they themselves, as lawmakers, have just decided to ignore it. And then,
Mr. Ngcukaitobi, in that regard, it's also common cause that on the same day of the report, the 1st of April, both the EFF and the DA, their representatives from the committee email the secretary of the committee and say that's not what was agreed in the committee.
Indeed.
And this report does not accurately reflect the situation.
yes, indeed.
And the following day, in spite of that, and in spite of then letters to speak a vote by the DA and the EFF, to say don't go ahead with the vote.
Yes.
It's rushed through and the vote is held.
Yes, they ran through. They thought, we've got this gap now because Action SA is with us. Let's put it through.
Arguably, there would be a basis in which to say that an issue could be discussed by a committee, and the report could be a correct reflection of that report after the fact could then be sent to Parliament. In certain circumstances, fact dependent, that might be acceptable. But in this case, the facts show completely the opposite.
Yes, the facts show that the report was a distortion of what had happened. And that distortion was brought to the attention of the Speaker. The Speaker never testified.
What is to be made of the word approved in the minute?
Whatever that word means, even if it means accept, it is still undermined by the condition, which is also included in the report. Because the section says clear statement. And once you put the condition, it takes away the clarity. So it's the main argument, by the way, by the Speaker, is to say sometimes they use approve, sometimes they use adopt, but they always shy away from accept, which is the language in Section 8.4, because they know that accept is not conditional, even in contract. If you say I accept, but that's not an acceptance. So the third irregularity is then identified in the following section, which again is objections being raised, and when you look at the answering affidavit, that's not being addressed directly. And then the fourth one, there is a fifth one, okay, a sixth one, again no answers. A seventh irregularity, an eighth irregularity. And what you say is the content thereof is denied, the content thereof is denied. The ninth irregularity and the 10th irregularity. So we've taken the time to go through this quite carefully, and we've come up with 10 irregularities. So I'm afraid what you have, what the court has, is that it has a report that is so fundamentally undermined by the irregular way in which Parliament conducted itself, which is in conflict with Section 8.4, and therefore cannot be given effect. What that really leaves is, well, can you do the separation? We've showed in our heads of argument that you can't come and rely on a different section after the event. If the minister's case was always, I'm increasing that, I don't care about the budget and I don't care about the fiscal framework. That was never his case. That case came in the answering. So therefore, he was always trying to increase that as part and parcel of the budget and the fiscal framework. So he's bound by that election. Then, well, what is the court supposed to do? Well, we submit that it's inevitable that relief must be given to the EFF and the DA. The question is whether interim relief on the fiscal framework or final relief. We've asked for interim relief. Mr. Bishop, as I understand him, says that interim relief might not be appropriate because it would sterilize parliamentary processes until Part B is ready. It's unclear to us why it would, because if the current process is interdicted, it's clear that they may not proceed with it. But that doesn't mean they may not start a new lawful process.
Can I just ask paragraphs 3 and 4 of the relief, which suspend the report of the standing committee and then the reports of Parliament after that? Has the boat not sailed in respect of that report? What would the suspension of the report do? Because that has already that's gone through the process and voted on. And so what would the suspension of the report of the standing committee do at this stage?
Well, my lady, we do ask in paragraph 4 for the suspension of the National Assembly resolutions. What we were worried about is that the court might say that there was nothing wrong with the National Assembly resolutions, and therefore we have to attack both of them. But again, if you only gave us paragraph 4, theoretically, you still have the problem that you've got the poisoned report of the standing committee, which still remains and has not been suspended.
What I think my question goes to, is it not the setting aside that should be granted rather than a suspension? Because a suspension, what does it really do?
Yes, it may not be just an everything. And let me just say this. The relief that should be given is just an equitable under section 172, and that's what Godans is. And also says that you are not bound by my formulation of the remedy. What you must give is what is just an equity.
So if it was final relief, you would be covered.
Yes. That would be given. I submit that I do meet the threshold for final relief, but we had asked for interim relief. But the fact is that the facts are so clear and the law is so clear that the court will be entitled to give final relief in this discussion. If the court gives final relief to the DA, then my arguments are only supplementary to the DA. I don't need separate final relief.
Okay. If for instance, we give final relief to the DA, and then paragraph 5, which is the interdict, would still stand. Is that right? Is that what you're saying?
Yes.
So in respect of 3 and 4,
yes,
we can actually give the final relief in respect of that, but paragraph 5 still stands because that's the interdict pending Part B.
Yes, indeed, because there is Part B even on the DS formulation of the case. But I still need Part B anyway because I need to finally set aside the VAT increase.
Okay. So Part B in this instance would only be in relation to the VAT increase and not the report, because the reports would have been catered for in the final relief.
If you give the DA final relief, then I don't need any final relief. My arguments will simply support what the DA has said.
Okay.
But it's in that event that you think final relief is inappropriate that I say my paragraph 3 and 4 are appropriate.
Okay.
I have nothing else to add. There are 4 of us. We should be entitled to cost of 2 counts. This is sufficiently complex. We are immunized from cost by bywash.
Yes, we can start according to 2.